Hey there. Welcome to the Adoption Roadmap podcast, where we talk about navigating the adoption process and beyond. Before we get into the episode, here's a quick word from today's sponsor. The choice to place a child for adoption is one of the most profound and difficult decisions a woman can make. Many birth mothers describe feeling supported during the process, but unseen afterward. Solace gift boxes were created to change that. Each box honors birth mothers in their ongoing motherhood with beautifully curated artisan-made items from small businesses. Choose from 3 themes: Peace, Love, and Pamper, the Paper Crane, and the Light Box. Available in 3 sizes, all $59.99 or less, with shipping included. Don't know a birth mom personally? You can sponsor a box and Solace will send it to a birth mother nominated through their community. Solace is a project by Absolute Love Adoption, a licensed 501c3. Learn more or send a box at adoptsolace.com. Link in the show notes to learn more.
What does it take to navigate some of the most complex and emotionally charged adoption cases in the country? Jeannie Gillespie knows. Genie Miller Gillespie, a powerhouse attorney who's been practicing adoption, guardianship, and reproductive law for over 3 decades, has handled thousands of cases, including several high-profile and precedent-setting ones, and is one of the most trusted legal minds in the field. A former president and current policy director of the Academy of Adoption and Assisted Reproduction Attorneys, or Quad A, Jeannie is a true changemaker. She has trained hundreds of attorneys, shaped legislation, and dedicated her career to protecting children, empowering families, and elevating ethical standards in adoption. When I have a legal question, I am lucky to have Jeannie's number on speed dial. This is her first ever podcast appearance, and it's an important one, especially for hopeful adoptive parents. Let's dive into the real legal landscape of adoption with one of its most respected advocates. Hi, Jeannie. Welcome to your first ever podcast. I'm excited it's with me.
Yeah, thank you so much. I'm excited too. One super quick disclaimer. I'm here today on my own behalf and not on behalf of Quad A.
You have been in this field for over 30 years. What's changed the most in adoption law since you began, and what still hasn't changed enough in your opinion?
I think the thing that has changed the most is the level of openness in adoptions. I think there's been a ton of research and, all the professionals agree at this point that it's really important, especially for the child down the road, to have some level of openness. Back when I started, everything was, completely closed. There were no match meetings. There were no, expectation of future contact between adoptive parents and biological parents. And now I think that has shifted completely. And I think it's really important for everybody to know that because I also, though, going along with that, it's very important for adoptive parents to think about what level of openness they're comfortable with, because we don't want people making promises, that they don't intend to follow through on. That's not fair to anybody. But, and not, the levels of openness that everybody sort of expects at this point are not, we've got 4 sets of parents for this child, or, on a daily basis, or the birth parents are expecting to come over for brunch every Sunday, or, whatever works for your situation is the right one. There's no right or wrong answers, but I do think it's important to have a better understanding of what openness means. Now, openness also, though, is not necessarily enforceable in every state, right? Some states do have enforceable post-adoption contact agreements, or PACAs for short. Some states like Illinois, where I practice, don't, but we do enter into what we sort of call good faith agreements, so that, at least expectations can be outlined. But that's the biggest change I think I've seen in the last 30 years.
I'm glad you clarified the openness thing a little bit. I actually just today got an email from somebody who wanted to start working with RG Adoption Consulting, and we have a form, and one of the questions is, what level of openness are you open to? And it's the spectrum, but closed isn't one of them. And she's emailed and said, I cannot fill this out. So I called her on the phone. And I was like, I'm a little confused, because when we first talked, and she said, Oh, I thought what that meant is that when the mom was comfortable parenting again, she could come and take her child. And I was like, "Oh no. Oh no, that
Oh
does." She's
gosh.
like, "Does that happen?" I'm like, "No, that's all fantasy. That does not happen. If she wants to happen, right? That's the Lifetime
That's
TV
the
movies.
Lifetime TV
If she wants
movies.
to parent, she will parent. But if she places with you, she does want to know that she made the best choice for her child and that she still loves her child, um, and that her child, knows who she is, which is the best case scenario for the child as well. So I'm, yeah.
Right. And I agree. I think it's important to, most of the time the
Hmm.
birth parents really just want to know that their child is okay. So updates, letters, pictures, emails, there if you're not comfortable sharing your, address, et cetera. I mean, you can set up email addresses that don't have your name in them. You can set up, there's all sorts of
Yep.
online picture sharing things at this point. So lots of great options. You don't have to be
So
scared of
are
the
there things
concept
that
of
you think
openness.
still should be changing or started to change but aren't quite there that you can think of?
I think, well, one thing is
Mm.
open access to records. I don't think adoption records should be open, and that's not what I mean. But I do believe there's quite a few states now, and I have not checked lately to see what the current tally is, but that allow access to original birth certificates for adult adoptees. And it's not to be used for identification purposes. It's usually not a certified copy that they can use to change their name or anything like that. But I do think it's useful for especially for the adult adoptees
Mm.
that may have been part of more closed adoptions in the past to get access to some of that
What do you
information
mean
about their
adoption
biological
records
parents.
shouldn't be open? What do you mean by that?
I mean, adoption
Okay.
records in court files and things like that should not be accessible. Those are in most states. In fact, I'm almost probably all of them. They're confidential documents. They're confident. They're sealed so that nobody can, like in Illinois, for example, and other types of cases other than adoption, I can go online and I can pull up a docket and see documents
Okay.
that were filed in a different type of case.
Oh,
Adoptions, that's not possible. They're not accessible because of all
right.
the
Well, that makes
confidentiality
sense.
involved. And we want to protect everybody's confidentiality. And even when we're talking about openness and future contact, there's still information in the adoption records that we don't necessarily want the birth parents to see or the
Got
child
it.
to
I never
see,
even
those
thought
sorts of
about
things
that.
down the road.
Jeannie, in your estimation, and I don't know if there's any real numbers on this or not, but what percentage of adoptions do you think end up being contested, or do you know end up being contested? And what usually drives those disputes?
So I don't actually have statistics on that in terms of how many are contested. And part of the reason for that is that because first of all, very few adoption decisions are appealed, right? So that's usually how you find out about law being changed or things like that. Even if there's, a contested case, it usually either
Mm.
gets worked out or, whatever happens. Um, but I actually think the number is pretty low in terms of how many adoptions are contested. And I think that's because of sort of all of the pre-planning and work that goes into the placement prior
That's
to
good.
actual placement.
Mhm.
Um, yeah, no, and I think so. I mean, I think, certainly when you're working with an adoption agency, they work really hard, for example, to figure out, if the biological father is on board with the plan, and if not, what they can do to either, you know, convince him to be on board if the adoption is going
Mhm.
to go through, or maybe he wants to parent and then there won't be an adoption. Um, I think when they are contested, it's generally by a biological parent, obviously. Um, but again, I don't think it happens that often. I mean, I think occasionally you hear about cases where a biological mother signs a consent or a relinquishment to an adoption and then changes her mind and tries, to undo it. But in most states, those consents are final and irrevocable. So there's not much they can do there, which is why there's, again, so much pre planning and pre discussion and counseling and all that stuff that goes into it
Yeah, and just
before
to
she
distinguish,
signs.
we're not talking about an adoption that at the last minute doesn't go through. We're talking about an adoption that goes through, mom signed, and then something happens where it's contested.
Correct. And those kinds of contests are generally going to
Okay.
be probably by the biological father or putative father or, legal father. Again, we can talk for days about all the different types of fathers involved in adoptions, but potentially, even though biologically we know there's only one child, one father. But that's generally and it's likely to come about because maybe the mother didn't identify the father and then he comes forward later, or maybe they know who it is, but he initially says he's on board and then he changes his mind. There could be a variety of reasons for that. But I think for your listeners, I think it's important to know that there just aren't that many in truly contested adoptions, which is great because again, then you won't end up
Yeah.
the subject of the Lifetime TV movie, right?
So of the contested adoptions, it sounds like the majority of them are through the fathers coming forward. Would you say that's true? Mhm.
True, because there wouldn't really be a placement if the mother's
Right.
not on board, right? You can't. There are situations like safe haven and things like that where you wouldn't
Can
necessarily know who the
another
mother is
family
either, but
member
those aren't going to
contest
be
it?
contested. So generally, it would in most states not really.
Okay.
They don't really have what we call standing to contest an adoption. Sometimes some states have grandparent rights laws and things like that, but that's more about visitation and future contact, not about
Okay.
being able to contest an adoption. Generally, if you see a challenge from a relative, grandparents, etc., it's going to happen prior to the placement. They're going to, try to convince the mother to parent or whatever, so that they or they can step forward at that point and say before she places or makes a decision and say,
And I
I would like
guess
to
what
raise
I'd
your child,
yeah,
that
go
sort of
ahead.
thing.
Sorry, I didn't mean to cut you off.
But no, I was just to say in most states, though, I don't think anybody other than the biological mother or biological or legal or putative father would
Good to
have the
know.
right to
I've
challenge the
had that
adoption.
question before. When it comes to the father and before you take a match, so it's complicated, right? Nothing's ever easy in adoption, as we know. But first and foremost, that's something you need to look at when you're presented the information. Sometimes I get presented a situation that says absolutely nothing about the father, and I'll always ask, tell me something about the father. Does he know she's pregnant? Does he know that she's placing? If not, why not? All of that. Um, there are times, and I have had this happen to some of my clients, where mom says she doesn't know who it is. And she's lying. She does. And it comes to bite everyone in the ass later. Um,
Right. In some states, like in Illinois, for example, the mother has three options related to the father in terms of identification. She can say, number one, I know who the father is, and here's where you can find him, here's his name, etc. She can say, number two, I don't know who the father is, and this is why I don't know. But she has to have some sort of reason. It's usually multiple partner type situations or things like that, right? Or in Illinois and some other states, she can say, option number three, I know who the father is, but I'm not going to tell you. And the reason for those generally tend to be more domestic violence, assault type situations, but not always. She doesn't really have to have that as a reason. Um, in Illinois, under our statute, we're allowed to rely on whichever option she chooses. Even if she says, I know who it is, but I'm not going to tell you, we can go forward with the adoption. We just have to take extra steps to make sure that we terminate parental rights of any unknown fathers out there in the world so that, you know, the adoption is secure before, when it's finalized. Because again, we don't want somebody to,
I would
come knocking on the
imagine,
door
though,
many
that
years
that's
later.
kind of the same thing, maybe not spelled out that way. But listen, you can never force somebody to name anybody they don't want to name. And I think that that's sometimes an issue that people don't think about when they're talking about certain laws in certain states with fathers' rights, and these are better and these are not, and in this state she doesn't have to name them. Well, in any state in the country she doesn't have to name them if she doesn't want to.
Right. You can't force her to, if she's willing to lie, for example, and say,
Right.
I don't know who it is, you
So
can't really stop that, right? But that's why you have to have an attorney, and an agency that's working with you to make sure that they're shoring up those rights and terminating any potential rights out there. Not just a potentially named father, but also any unknown fathers. Most states have a law that allows you to do that,
do most
by
states
after
have that?
jumping through several hoops. I think a lot of states do. I've never actually counted. Every state has a
Okay.
way of making
Yeah.
the adoption secure, right? Some states we have putative father registries, which we can talk about in a few minutes. Some states don't have those, but still, have a mechanism for identifying and serving, et cetera, a father that's involved. I don't know, in some states, I guess in theory, if I'd have to talk to some of my colleagues. I don't think there's any state that would allow an adoption to
Yeah.
finalize without
So
closing that door.
going back to what you should look for. So first and foremost, make sure he's mentioned somewhere where it's written out about the situation and when you're looking at if you're comfortable or not presenting. And if it's not, you need to ask some questions. Always ask questions. If they say she just isn't naming him or doesn't know him, you can still ask why. And then it sounds like you can say,
Mhm.
okay, if she's not, what are we doing to protect this adoption? Which I never thought to ask in those words until this conversation.
Yeah.
So that's good to know.
Yeah, I think it's very important. And when you're evaluating, what we call legal risk, I think that's one of the things you have to definitely get answered, to your satisfaction. What are we
All
doing
right.
about
So
any potential
legal
fathers out
risk.
there?
What does that mean?
Yeah.
What does
What does
that
that
mean? What
mean?
is this term legal risk in
Legal
adoption?
risk. Well, right. So when you're evaluating, a potential match or a potential situation, first of all the mother, obviously, who's involved, and presumably she's going to sign a consent, relinquishment, surrender, whatever that state requires. Um, the father situation, you don't always know. And again, for the reasons we were just talking about, she may not know who it is. There may have been multiple partners, et cetera. For example, there may be two or three potential fathers, um, she may know who it is, but she may know that he absolutely is against the concept of adoption and isn't going to sign off on it. So she may choose not to identify him. She may not, she may not even tell us, any of us, that that's the situation, that she knows he's, basically completely opposed to adoption. Um, but that's where legal risk comes in, is you have to determine with your attorney, with your agency, what level of legal risk you're comfortable with, but also B, what are we going to do about it? If there's legal risk involved, because for example, she's identified three potential fathers, what are we going to do to protect the adoption, to finalize that adoption, while dealing with all three of those fathers? Can any of them come forward and disrupt my placement? If so, when? If so, how? I mean, those are the sort of legal risk things you need to think about.
I don't even know.
It's a lot. It's a lot to think about. I mean, for example, and I guess we could jump to putative father
Before you do
registries
this,
if you
so
want,
one of
because
the
that's
things
sort
I
of
was
part of the
thinking
legal
about
risk.
when you were talking about that is, yes, there's this thing with multiple fathers, and there's also, well, she's married but slept with another guy, and her husband is not the father of the child. So can you mention that, like what the
Correct.
terms are? Yeah.
Yeah, we've had that scenario before too. A legal father, there's most states have a presumption that the husband is the father of a child born during the marriage. Period. If the mother has been separated for a long time or may have had an affair or something and knows that somebody else is the father, there's a couple different ways that can be handled. The husband can sign away his parental rights, and even if he doesn't technically have any, he can sign away, basically waiving the presumption that he's the father. He can sign, in some states like Illinois and a few other states, he can sign what we call a waiver of parental rights, where he doesn't admit or deny that he's the father, and he can waive any potential rights he might have, even if he's not the father. He could also, though, because he's the legal father, and under most states' laws, you need the consent of the father. You can have him sign a consent to the adoption, even if he knows he's not the father. You just have to, have the disclaimer in there that that he's doing this because he's the husband and the legal father, but not because he believes he's the actual father. Another thing you can do is you could actually do a DNA test. I mean, it's very rare that we do DNA tests in adoptions, but you could do one to show either that the legal father, the husband, is not the father, or that the actual father is the father. And then, it's easier to deal with legal fathers. I mean, I had a case many years ago where her husband was in prison for many years. And he refused to, sign, do anything, waivers, he would not get involved at all. The person that was the actual father didn't want to consent or do anything either. But ultimately, basically, we actually got an affidavit from somebody at the prison confirming that there were no conjugal visits allowed at the prison. So there was no way that he could be the father of the child. And then we ultimately,
So if
served him as well.
DNA,
But
yeah, if in that
you have to
case,
get
or if
creative.
DNA is taken and proven that the quote unquote legal father who's the person she's married to, isn't the biological father, is he off the hook then? So weird.
Not completely, because again, there's still that presumption. And I don't practice in the
Yeah.
area of parentage and divorce and custody, so I don't know as much about that side of things. But my understanding is because you can have sort of de facto parents too. I mean, he could be the husband who's not the
Mm,
biological father, but he could have been raising the child, right? So he might have more rights
yeah.
it's not going to come up necessarily in an adoption setting, but because of that, he's not completely off the
Yeah.
hook. You still want to get him to sign a waiver or something, because he could, in theory, try to overcome the presumption. It's very difficult, obviously, when there's actual
Have you ever
DNA
seen that
results,
happen?
you know,
No.
but still, I have not. I have not. And in fact, in all my 30 years, I've only had two situations where somebody actually wanted a DNA test. And one of them was, it was a case where the mother had identified three potential fathers. And one of them honestly was just curious because I guess he had had cancer as a child or something. And he
Yeah.
was just curious whether he could father a child. So he asked for a DNA test. It turned out he wasn't. But, but he signed a waiver of any potential parental rights even before the DNA test. So that wasn't a big deal. And then a few times when a father has come forward, before, like, putative father registries differ state to state, but, like Illinois is 30 days. We had potential father come forward before those 30 days were up. And we, of course, requested a DNA test just to confirm before we,
All right. So
to know
talk
that was
about
going to potentially
what this
disrupt the adoption. We needed to know for sure.
right? Putative father
I know
registry.
it's confusing. I know it's funny because actually
Right.
a lot of people call it punitive, accidentally, and it's I guess it is kind of punitive when you look at it. So I know it's putative fathers. So any person that could potentially be the father of a child. So it's not somebody who's married to the mother, because that would make him a legal father.
But could it
It's
be a
not
legal
somebody
father?
who's on the birth certificate. Again, that would make
Or oh.
they're not a putative father. No, if there's the difference. So there's biological fathers, there's legal fathers,
Oh.
there's putative fathers. So all right, well, here, we'll start at the
Yeah.
beginning. Biological parents, we know DNA or whatever has proved them their father. A legal father, somebody who's either married to the mother at the time of the birth or within 300 days prior to the birth, so that, even if they got divorced, could still be the father. A legal father is also somebody who's on the birth certificate. In most states, there's some mechanism for getting a father on the birth certificate that requires them to take an active step, not just mother naming somebody. So they have, like voluntary acknowledgments of paternity forms, things like that, where they end up on the birth certificate, even if they're not married. So that's still a legal father. There could also be a person who, even prior to the birth of a child, files a paternity action trying to get a declaration that they're the father. If that happens, that would make them a legal father as well.
Hey, Adoption Roadmap listener. It's podcast editor Josie here, and we've come to the end of part 1 of this episode. And I know that you really want to listen to part 2, but you're gonna have to tune in next week. But listen, I'll make a deal with you, alright? I'll tease part 2 of the episode if you leave us a rating and review. It really helps shows like ours reach new audiences. So, pause this episode. I'll wait. Drop your rating, review, like, stars, whatever it is, on whatever platform you're listening on. Alright, did you do it? Are we back? Okay, I'm trusting you. Now here's a teaser of part 2.
So he found a lawyer, he filed an action in court, and he and the adoptive parents battled it out in court all the way up to the Illinois Supreme Court. It took them over
Was
4
there still
years
right?
to get a decision.
How
And
did
at
they
the
even
end of
have the
that,
right to do that at that point?
because there was no registry, there was no anything. He just
There
came
was
forward. He
no
said, "I'm the
law
dad." He
about
did a DNA
okay.
test,
Okay.
and there was nothing in the law at that
Wow.
point. Because again, this was 30
Mm-hmm.
years ago. There was nothing in the law that addressed that. So it went all the way up to the Illinois Supreme Court, and after I think 4.5 years, the adoptive parents actually had to give the child back to the biological parents.
All right, friends. That's a wrap for today's episode. What was your biggest takeaway today? If you found this conversation valuable, inspiring, or even just entertaining, I'd love for you to leave a 5-star rating and review. That's how more people find this show and how we spread education and support across the adoption community. Hit follow, leave a 5-star rating, and share this with someone who could use it. We drop a new episode every Wednesday morning. Catch you next time on the Adoption Roadmap podcast. Thanks for being here. Bye-bye.